Alrighty. Hey, everybody. Welcome to West Side Meetup. It is a little after 7, and we just want to honor everybody's time and get the meetup started. So if this is your first time, welcome. My name is Brandon Rabe. I'm an active investor. I'm also a real estate trainer and a co-host of this meetup, along with our in-person meetup called Real Estate at the Park. That's where we meet in person at one of the parks here on Oahu, and we get to know other investors, and yeah, we just network. So thank you guys for being here. Before we move forward, I did want to share with you guys something. It's the fee, and basically it's from tonight's presentation. If you guys find value from it, if you guys learned something, if it shifted your perspective, I want to ask you guys to share our meetup. Invite somebody to the next one, take a screenshot, share it on your social media, whatever it is. We just want to organically grow this community and share the information of our speakers with more people. So that's all we ask. If you guys can share our meetup with other people, that'd be awesome. But yeah, so thank you guys for joining us tonight. To kind of segue into our next introduction portion, I just wanted to bring up our co-host, Gilbert Coloma, as he kind of brings on our guest and also talks about the meetup. So what's up, Gilbert? How you doing, man?
All right, let me unmute first. But yes, Brandon, thank you for bringing me on, and thank you to everyone spending time with us this Wednesday evening. And first and foremost, for those of you that don't know who I am, my name is Gilbert Coloma. Like Brandon Rabe, I am a WNN advisor. I invest out of state in the Midwest to grow growing my portfolio out there for passive income. Hopefully, gonna retire sooner rather than later to get that time freedom, right? That's what we all wish for. But before we get into the presentation here, I'd like to go over some housekeeping rules, right? So first, this meeting will be recorded and posted online. If you wanted to watch it again later, if you missed something or want to share it with some friends later. So we'll be putting it out on the YouTube channel also. Second, I'd like to ask everyone to please mute your mics to minimize distractions for our speaker and for everyone else. Third, if you have any questions, please post them in the chat. I think we got a very good topic tonight, so please post them in the chat, and we'll have the presenter or someone else chime in and answer the questions during the Q&A portion of the presentation, right? Which will be following Jarrett's presentation here. And lastly, please stick around after the presentation and Q&A as we transition into open networking. Networking is where the magic happens in real estate investing. So with further ado, I'd like to bring on Jarret Macanas, and he could introduce himself. Welcome, Jarret.
Hey, Gilbert, thank you so much. And thank you, Brandon, for having me, and everyone who's listening in and participating through this call. Thank you for being here tonight, and aloha. I'm going to ask, let's see, you guys can see my slideshow. Just give me a nod, Gilbert, please. Let's see. Okay, I'm assuming you can see that. Tonight, we're going to be talking about the basics of an LLC, limited liability companies. And the title of the presentation is the ABCs of LLCs. In other words, we're going to go over the very, very basic concepts and move through those concepts into some advanced ideas and strategies and things that might be of interest to you. But before I go any further, I have to give a legal disclaimer that the information that I have to share tonight is basic education, and it's just informational in nature. It doesn't create a client-attorney relationship, but it's designed to give you a foundational understanding of this area of the law so that you can ask the right questions with your attorney one-on-one. A little bit about myself. I am a lawyer here in Hawaii. I practice primarily in estate planning and LLCs. I've done my undergraduate work on the mainland, BYU-Provo, University of Utah Law School, and a master's in tax law from Boston University. I've been doing this for about 18 years exclusively. I started off as an estate planner focusing on wills and trusts, and a lot of my clients are small business owners and investors. And so that dovetails right into small business planning and having to work through family limited partnerships and LLCs for both business purposes and real estate investing purposes. I've had the opportunity to help a lot of people, a lot of clients create LLCs for different reasons, for setting up a new business and for purchasing real estate or getting involved in real estate investing. And so I've seen the plans that work well, and a lot of the information I'm sharing tonight is based off that experience. One thing I think is really commendable to all of you who are participating tonight is that you are investing in your future, that you are taking wealth building seriously, that you see how important it is to plan ahead and think about not just what's going to happen in the next week or day, but you're thinking well beyond that into the next generation. And so I really like this quote. Something to think about as it's going to tie into some asset protection concepts. And that is, planning ahead is a measure of class. The rich and even the middle class plan for future generations, but the poor plan only a few weeks or days ahead. So we have to think long term and not just for ourselves, but into the next generation and so on and so forth. Well, first things first, I want to lay a foundation to help you understand why LLCs are important. And that's just the risk of litigation or being sued. So according to some studies that are published in Forbes business magazines, you have a 10% chance of getting sued each year. And that likelihood continues to rise over your lifetime, up to about a 33% chance for most people. And so that means if we had 100 people, 30 or so are going to be involved in some kind of lawsuit. And of course, what they do in their individual lives, what they're involved in on a day-to-day basis can contribute to increasing that likelihood of being sued. If you're engaged in activities that are a high degree of risk or expose you to risk, that likelihood is going to go up. A lot of times when people first think of being sued, they don't realize that their homeowner's insurance policy is usually the first policy to respond. That's the biggest asset for most people is their home, their home residence. And so that's where all the equity is. That's where all the value of their estate is. And so that's the first place a creditor might look to try to get liquidated to pay their claim or their judgment. And if the home and auto insurance policy is not able to cover the amount of damages that are awarded or involved in this lawsuit, or it's not covered because it has something to do with something that's excluded in the policy, then there might be some help coming from what's called an umbrella policy. And this is something that you should look into with regard to an additional protection from lawsuits and from other things that could take away from your estate and your assets. And that's an umbrella policy. And these are surprisingly affordable. I was looking at some quotes a few days ago, and I saw some quotes in the neighborhood of for a $5 million coverage, the annual premium was about $600. For a $10 million coverage, the annual premium was about $1,000. And you can do $1 million, you can do $2 million, depending on what your net worth is. But those umbrella policies are pretty affordable. One thing about them, however, is you need to understand what they don't cover. So it's a good thing to have as an additional piece of protection, but you should also be aware of what the policy does not cover. If your home and auto policy can't cover the damages, your umbrella policy isn't going to apply or not going to kick in, then the rest of your assets will be exposed to a potential lawsuit or a judgment that can come in the form of a lien or wages or garnishments on income, things of that nature. We can be sued for pretty much anything nowadays. This concept of what's called vicarious liability, that means that you are responsible for the actions of others that you have a duty or control over. So for example, your children, your agents or employees, or your tenants, people that are under your direction or control. If you're negligent in managing them, you could be responsible. So common scenario, or not common scenario, but it's funny, in my career, I've had 2 incidences that sounded the same. And that is, I had 2 families where their kids were involved in an altercation at school. So in one situation, their child threw a rock at another child, and so they were responsible civilly. And in the other case, a couple's child pushed another child off a play structure, and there was some injuries there. In both cases, the families were responsible for the actions of their children. You can also be sued for anything: car accidents, boating accidents, faulty installation of a deck or stairs, or anything that you're working on if you're building. If you have a partnership agreement with someone, or if you're pooling your money together, or you're dealing with others as a group, you might have a dispute, or you might have a business dissolution or a termination of your partnership that could go south. And those can turn really, really ugly. A lot of times I see that in the case where we have a startup, and 2 friends get together. One has the ideas or the concepts of the business, the other has the know-how, the knowledge or the experience to put it together, and then they never put anything into writing, and there's breach of contract. And so there's oral contracts, or there's promises that were made, even if those promises were made in jest, like on an email or a text message. And so you can be sued for pretty much anything nowadays. So I want to help explain for you, or help you understand the goals of what we refer to as asset protection. So when we say asset protection, what we're referring to is setting things up in advance, or planning ahead and putting things in place so that we have the greatest chance to protect ourselves from personal liability. In other words, protecting our personal assets, our bank accounts, our savings, our retirement, our homes. And the way that we do that is, we set up strategies to account for that. I mentioned insurance already. There's a lot of other different types of strategies beyond insurance and LLCs, but those are just the ones we're talking about tonight. But I want you to know that it's not an exact science, or it's unpredictable in the sense that, the courts, this is a relatively new area of law where courts are still handling asset protection cases. There's not a lot of case law or opinions or cases that have gone through the entire court system, all the way up through appeals and into the Supreme Court, either state or federal. And that's because most of the time these lawsuits are being mediated out or settled, or there's going to be some sort of settlement agreement that occurs along the way. And that's where the value of asset protection comes in. And what that means is putting things in a way where you would have some bargaining tools or some leverage to reach a settlement in an alternative dispute quicker. For example, you might say, well, okay, we're getting sued, but we have these entities, these LLCs that we've created, and they're filed in different states. There's holding companies or shell companies. There's a lot of different things that we could do to prolong the litigation. We can file motions to change states or venue. We can stall. So, there's a lot of different things that an attorney can do to make things difficult for the creditor or the creditor's lawyers to encourage them to want to settle and mediate sooner. And so that puts us in a favorable light. And really what we're doing is we're taking advantage or availing ourselves to establish creditor-debtor law. So there's creditor-debtor laws out there that have been enacted for this purpose, and we're just taking advantage of it. We're availing ourselves to those protections, and we're doing so under established law. And so it's nothing that is illegal or suspicious or unheard of. It's just we are using the tools that the law gives us. I mentioned it's important for us to plan ahead and do these things in advance before we're sued because of the concept of fraudulent transfer rules. And what the fraudulent transfer rules refer to is that if you're sued and you immediately try to take all the property out of your name, take your name off your house, take your name off your bank accounts, your cars, transfer them to a spouse or to someone else. All of those transfers can be undone by a court. So once you've been notified or of pending litigation or the event has occurred wherein a lawsuit would be the result, it's too late because the creditors can compel a court to undo or call back those transfers. And so Hawaii has laws on the books regarding this concept of asset transfers during pending litigation. And there's some severe penalties for that. So it's illegal to hide, conceal, or remove assets. You can't take your name off assets once you are involved in litigation. You cannot hinder, delay, or defraud your creditor. Okay, so I mentioned that we work with a lot of real estate investors. And when I first started my career, I was involved with a lot of corporations and limited partnerships. And these were entities that were used in the 70s and the 80s because that was the only type of business formation that a real estate investor could choose from. And this is all predating the year 1977. And in this era, 1977, people were still investing in real estate. They still understood the concept of separating their personal assets from their business endeavors, and they wanted to create a degree of separation. But at that time, the only two choices of businesses that they could form were a corporation or a partnership. And corporations would give the investor that degree of separation, that corporate veil, as they call it, to separate their personal assets from business assets. However, the corporation was taxed differently, and until an S corp came along, corporations were taxed twice, at the income, business, or entity level, and then again when distributions were made to shareholders. So it was double taxation issues. Partnerships, on the other hand, were a little bit easier to form, less formalities and requirements in the corporation, but they offered no protection, no corporate veil. And so they created a hybrid of a partnership called a limited partnership. And that was the primary tool or most common form of doing real estate investing prior to 1977, because the limited partnership was a little bit flexible in terms of how it was created and managed and maintained. It didn't have a lot of the formality requirements like a corporation. It didn't have the taxation issues, but it did offer some limited liability, which means that a limited partner would not be responsible for the business assets. A general partner would, and usually that general partner would be a different type of entity. So those were kind of the makeshift strategies that people had to use back then, until 1977 came along, and the state of Wyoming was the first to introduce a new type of business, a new concept called the LLC, which was the limited liability company. And it was a hybrid of all the good things from the corporation, all the good things from the partnership. So from the corporation side, there was a limitation on the liability for the business owners. There was that corporate veil. There was a degree of separation from personal assets and business assets. On the partnership side, it was they took all the good things from the partnership side, which were ease of maintenance and formation, not having to have board director meetings and annual shareholder meetings and all the formalities that are inherent in running a corporation. And so it was a very useful tool for investors because they can invest in real estate through an entity called an LLC and not have to go through those administrative hoops of doing a corporation. And then in the 90s, the IRS issued what's called check the box regulations. This refers to the fact that LLCs are only recognized by states. So an LLC is only recognized at the state level, and the federal government does not recognize LLCs. And so when you form your LLC, you still have to pay federal taxes. You still have to report income on the company, but the IRS has allowed us to use a choice or a selection of how we want to be treated for tax purposes. And so, for example, you can form a LLC and elect to check the box and be treated as what we call a disregarded entity. That means all the income goes to you personally and taxed on your personal 1040, or if you're married, if you're married, filing jointly to a couple's return. But that offered a lot of flexibility in tax planning. So the IRS was in support of these LLCs, but the federal government hasn't created a federal statute that covers LLCs for all 50 states. We're just left with each individual state, which is a really important fact to remember when it comes to how these LLCs are going to be treated. I mentioned that the LLC was given this check the box regulation option, so the taxes are going to be easy to plan for. You have a lot of different options. You can work with your CPA on what's the best way to be taxed. And then you can also set up a lot of different ways to manage your LLC. Most LLCs are going to be what we refer to as managed. That means the company has one manager, and the manager is like the CEO of the corporation. The manager has the authority to sign contracts, documents, open bank accounts, that sort of thing, where the members of the LLC or the owners of the LLC would only participate by certain instructions and guidelines to that manager. I mentioned that this started in 1977, so we're 50 years, almost 50 years in the making of LLCs across the country. All 50 states now have an LLC statute, but their regulations are going to vary from state to state. So one state might have very strict and complicated rules for forming an LLC or creating an LLC. It might have different requirements with regard to notice to the public. Some states require new LLC owners to publish a notice in the newspaper. Other states, on the other hand, are a little bit more private and they don't require so much publicity, and you can remain anonymous. There's a lot of different variations of these states' laws on LLCs. And so when you get into living in one state and forming an LLC in the state where the rental property is located, you're dealing with two different states. The biggest issue with a variation of state law is with regard to debtor-creditor laws, because some states are very weak when it comes to asset protection in light of the investor. So from the investor's perspective, from the investor's view, some states might be horrible places for asset protection because they have more options for the creditor to choose from, and they're more creditor friendly. They give more deference to the creditors and the creditors' attorneys, and so those states are not very strong when it comes to upholding asset protection laws for the debtor. There are some states out there who have adopted specific legislation that attracts outsiders for that reason. So some innovative states are like Delaware, Wyoming, Alaska, Nevada. These states have purposefully enacted specific legislation that encourages people to come to their states because of their favorable asset protection laws. One example could be in the state of Wyoming, they have very lenient privacy laws. And so if you wanted to maintain your privacy and be anonymous and not be on the internet, then you could go through a proxy company to initially form the LLC in the state of Wyoming. And after it's formed and active, that proxy company would sign over a power of attorney back to you, or you would have had signed a power of attorney to that proxy agency to initiate the paperwork to form the LLC so that it's their name on all the records. But then as soon as it's formed, they get that back to you. And so your personal name is not found on any database. If someone were to try to look up the name of the company in the state of Wyoming's website, Secretary of State or corporate commission's website, they're all kind of different, but there's a database for looking up companies. If they were to look up the name of that company, they wouldn't find the actual owner. They would just find the proxy service. There is a concept with regard to domestic and foreign LLCs. What that means is if you form a LLC in one state and you want to do business in another state, you can take that original LLC and register to do business in the new state under what's called a foreign LLC. An example would be if you form a Hawaii LLC and you're investing in properties in Utah, and now you want to do business in Utah, you can register your Hawaii LLC in the state of Utah, but you have to go through a process to get recognized for that. Well, I think I've covered most of this information here. The LLC, limited liability company, there's variations of those names. You might see different letters after different words or businesses. For example, you might see the word PLLC or LLLC in Hawaii. A lot of those are just referring to professional LLCs or lawyer LLCs, but they all mean limited liability company. As I mentioned, LLCs are created by state law, and each state has their own individual set of regulations that control how these LLCs are created, maintained, and how creditors and debtors interact with them and how they're dissolved and terminated. There's a lot of different membership and management options that you can create for your LLC. The members of the LLC are like the shareholders of a corporation, and the manager of the LLC would be like the board of directors or the CEO of a corporation. So you have a separation between ownership and management. You can also do a single member LLC. These are very, very, very common. And what that means is you just have a sole member LLC. There's only one person, and that one person is everything: the owner, the manager. It's a manager managed LLC and is the sole member. And yet, again, the purpose of doing a sole member, single member LLC, same thing, would be to create a degree of separation between their personal assets and their business assets, have a different federal ID number than their social security number. If you're partnering up with other people and you're doing joint ventures or agreements, or you're borrowing money or pooling money, you're going to want to do a multi-member LLC, and those are very can be complicated in terms of building out a partnership agreement, which is called the operating agreement. The operating agreement is like a corporation's bylaws. It's just the written set of instructions. It's a guidebook on all aspects of managing the LLC. And the operating agreement is really important when it comes to charging orders, which I'll get to toward the end of the presentation. But it's in the operating agreement where you will find the clauses that would control a future termination of the partnership, whether that's because of a partner's liability, maybe the partner's getting sued, maybe the partner's going through a divorce, maybe the partner wants to retire, so there's a departing reason. And it's better to have all of that language in there at the beginning so that later there's not a dispute on how to dissolve the company. A lot of that relates to agreeing ahead of time how the LLC is going to be valued, whether that could be through a independent business appraiser, or if it's going to be something simple like book value, just the LLC's assets minus the LLC's debts. That's what the company is worth, and you divide it in half if there's two partners. But the partnership agreement, the operating agreement, is absolutely critical if you're doing multi-member LLCs. And again, you have the check the box regulations for your federal taxes, and you can confer with a CPA or tax preparer on what's the best option for you based on what you're doing. The advantages of an LLC, of course, is the personal liability. You can leave the business debts with the business. They're simple to form and create. They give you a lot of different options for management. They're easy to maintain. There's not a lot of maintenance requirements, as I mentioned, like a corporation's annual meetings. And they're not cost prohibitive. They're pretty affordable. You probably want to have an attorney look at your situation, but it's the cost of doing business, but it's not astronomical to where you'd have to think, okay, do I want to do that, or how are my funds better spent? I think that it's fairly cheap to set up an LLC, and they're very common for small businesses. They're very common for real estate. Going back to the creditor debtor laws on the LLC, there's an important concept that you should remember, and that's the difference between inside and outside creditors. An inside creditor refers to someone who is involved with the business itself. That might be a tenant if it's a rental property, or it might be something related to that property, but it's an action, or it's a creditor that came from interacting with the business itself. And in that situation, the claims of inside creditors are going to be limited to the business or the business owner's interest in that LLC. It stays with the business, and it doesn't get into the business owner's personal side. On the other hand, you have what's called an outside creditor. And this is a person who comes into the picture in the business owner's personal life. It has nothing to do with the rental property, but it has everything to do with the personal life of the business owner. And in that situation, a creditor might be attacking a business owner's personal assets and saying, okay, they have a home residence, they have bank accounts, they have investments, and in addition to all of that, they also have this Ohio LLC that holds Ohio property, and that's an asset to them, and we want that to be liened and used to pay our judgment. So I'll give you some examples of an outside creditor in a diagram in a few minutes. This is really important to understand, just these concepts of an inside creditor might be someone related or tied to the company. Outside creditor is something or someone from the business owner's personal side. So I mentioned that people use LLCs for investing in real estate because they want to separate their personal liability. And that's a very, very smart thing to do. And one of the biggest factors to consider would be the timing of creating this LLC. So the first option would be is you create the LLC before you acquire the property. And if you're financing it, you haven't even gotten to the point where it's going to be, you're going to apply for a commercial loan or a loan for the LLC. And so during that loan due diligence phase, they might have a different rate for you. It's a commercial rate. And, you might have to go beyond your traditional banks and get into non-traditional banks, or not necessarily hard money lenders, but banks that don't have such rigid requirements. And those are banks that service loans in-house. In other words, it's going to be a bank that can produce a loan package for you through your LLC, and they're going to service that loan themselves. They're not going to bundle and package it up and sell it to someone else. Those types of loans that are bundled and serviced, or bundled and taken and sold somewhere else, are very, very strict and may not allow you to do financing through an LLC. So that's a very common way to do things, is you go the route of involving your loan broker from the beginning. The underwriter understands that you're acquiring a property that's going to be a rental, and they understand that it's common for landowners and investors to form LLCs. but they will make you sign a personal guarantee so that even if you default on the loan, they still have all of their rights for foreclosure. Well, but just they're going to be involved. Now, the other option would be to create your LLC after the fact, if you're financing a project and you've already got the deal financed and funded and it's closed and it's in your personal name, and then you want to come back to it and put it into an LLC or transfer it from your name to your LLC. That can create some issues regarding what's called a due on sale or due on transfer clause. And what that means is that the mortgage company can call the loan due if they don't like that. If they find out about it, that you didn't ask for their consent. If you did ask for their consent, they'd say no. But yeah, since you didn't ask for consent, they can call the whole note due. That's rare, but it could happen. Another thing that could happen, as I'll talk a little bit later toward the end of the presentation, is it could affect your short-term financing goals. So if you were thinking of doing a HELOC or something like that, if it's under an LLC, then you're back to point one, going through the business underwriting process and getting a commercial rate. Some states like Hawaii have conveyance taxes on a transfer from a personal name to an LLC. And so you might have to just look at what those conveyance taxes are going to be before you do it, just so you know what the cost is going to be. Okay, here's my attempt at animation. I'm not a pro, so please don't judge me, but here's a common scenario of what we were talking about. We have an investor, and the investor purchases a rental in their name only. And then they bring in a tenant, the tenant's paying rent, but then there's some problem on the property, a slip and fall, an injury, invited guest, something occurs wherein now the tenant has a claim and wants to hire an attorney to file a lawsuit. And the attorneys are going to look to the owner of the rental property, which in this case would be the investor himself personally, and then his assets would be exposed. So we don't want that. We want to try to do something else. And that would be going with an LLC. So in this case, we have the investor, he has his LLC, goes through the process of getting a loan LLC or a loan through the LLC. And then the LLC purchases the rental property. And in the same situation, we've got a tenant with the problem that files a lawsuit. The attorneys are going to file a lawsuit against the owner of the rental property, which in this case would be the LLC. And his personal assets would be shielded. I mentioned some states are very, very weak when it comes to asset protection. And that relates to this concept of a charging order. What a charging order means is that when a creditor gets a judgment against you, they might have to go through different strategies to collect. They might have to go through a foreclosure or a termination or dissolution or some sanctions. And one of the creditor remedies is called a charging order, which is a lien against the income that comes out of the LLC. However, before we even get to these creditor remedies, another issue comes up, and that is which state law controls. A common example of this problem or this situation would be, imagine if you had a California driver who is driving in Las Vegas and gets into a car accident with a Utah driver. So which law would control there? We have two parties from different states, one from Utah, one from California, but the accident occurred in Nevada. And so courts are going to look through some factors to determine which state law would control. And when it comes to real estate, it's kind of the same thing. So for example, you might have a Hawaii resident who files a Delaware LLC. The Delaware LLC is registered to do business in the state of Texas and owns a California, you have a shell company. So the Delaware LLC doing business in the state of Texas also owns a California LLC, which also owns Oregon property or something of that nature. And so you've got this string of ties to different states that could create problems. That might be good. Again, if you're looking at a threatening piece of litigation, maybe you want to bring up those issues just to get to a mediation quicker. If I'm a creditor, or let's say you have a creditor, creditors' attorneys have won a judgment against a business owner, and they're looking at ways of getting their awards paid out, their damages paid. they're going to look to this menu of remedies. So some of the possible remedies that a court can offer a creditor would be dissolving the LLC, terminating it, foreclosing it, or putting a charging order on it. Again, a charging order is a court order that the LLC has to pay the creditor any monies that would have been going to the LLC owner. It's like a lien on the income from the LLC, or think of it as like a garnishment on wages. So that's important because some states like Nevada have created legislation that says by law, the only remedy a judge can offer is a charging order. The judge can't offer anything else. And they've done that because they want people to look to Nevada as a place to do business, and they get money from all these outsiders coming in and forming Nevada LLCs in the hopes that a Nevada LLC statute would hold up in a different court. But if a creditor is given a charging order and no income's coming out, then there's a standoff, and you're just trying to get yourself some leverage into settling this claim. I'm gonna kind of speed up ahead because I think we're almost running out of time. But Wyoming LLCs, you can do a single member LLC for Wyoming, and charging orders are honored there. But let me show you how a charging order works real quick. So you have an investor who forms an LLC. The LLC has the rental property. And in this scenario, this is an outside creditor we're dealing with. So the last two diagrams that I had, those were inside creditors because it was a tenant involved with the rental property owned by the LLC. And that was a situation, or that was a situation involving an inside creditor. This is an outside creditor. So let's say the investor is driving home and he gets into an accident. So this accident had nothing to do with the Ohio property, had nothing to do with the state of Ohio. It was in his home state, and it was for him personally. And so creditors are going to come forward, they're filing lawsuits against him. And what they're trying to do is get to all of his assets, trying to get to his bank accounts, his savings and investments and mutual funds, rent, anything that he has. And what they could say is, well, speaking to a judge, the lawyers might say, well, we understand that this investor also owns this Ohio LLC and he's taking income from it. So what we'd like to do is step into his shoes, step into the economic shoes, as they call it, of the investor, and take all the income that is coming out of this LLC. We want to lien that portion of money that comes out of it. Well, whether or not this income comes out of the LLC or not depends on a management decision. The CEO, or in this case, the LLC would be a manager, and that would be all based off of the operating agreement. So an operating agreement might say no income comes out of the LLC at all if there's a charging order. In fact, the LLC is going to shut down. No income comes out of it. It's going to move into a long-term hold situation, and it's going to invest in other assets or something like that. And so this charging order becomes a problem for the creditors. When you're choosing, okay, what state law are you going to go under to file your LLC? I would look at the different costs. What are the initial filing fees? What are the annual dues or annual licenses? Some states are really cheap upfront, but they have a little bit more expensive annual maintenance fee. You're going to need what's called a registered agent. And what that is a person in the state of which you file your LLC to serve as a receiver of registered mail. And so if you don't know anybody to do that for you, there's services that do that. They range about $100 to $300 a year. And they'll be on record as the agent for receiving registered mail and service process. Privacy implications, I mentioned, some states like Hawaii are very easy to find people. So if you look up an address and I see the address under this property is owned by XYZ LLC, I can go search XYZ LLC on our state's website, and I can find out immediately who the members are. So it does very, very little for privacy. As I mentioned, the states on the mainland, some of them have enacted some really lenient privacy rules where you can keep your name off of public record. Okay, here's some practical considerations of whether you should do an LLC. Number one, how much equity is going to be exposed. So if you have a rental property that is going to be fully financed and it's under 150,000, I'm just throwing a ballpark figure out there, but let's say it's a not a substantial amount, but it's going to be fully financed. There's not a lot of equity exposed because the bank still has the underlying first mortgage. And so maybe you can get by with insurance, perhaps. On the other hand, on the other part of that scale, if you have a $1 million to $2 to $3 million property that's fully paid off and there's no mortgage, then you definitely want to try to create a degree of separation for those assets. The number of participants, of course, this would be, and also related to the number of related parties and properties. What this means is don't put all your eggs in one basket. So if you have all of your rental properties under the same LLC, if there's a problem on one of them, it's going to contaminate and get into the others. And so what you might do is create, segregate them, separate them out, and put them all under separate LLCs. That way, if there's a problem on one of them, then it doesn't naturally and immediately affect the other two, or if there's three in that case. This kind of goes back to the degree of equity. What I'm talking about here, acquisition financing, is if you're going to buy a property, how are you going to pay for it? Is it going to come from your savings and it's all cash, or is it a mix? Is it going to be through different types of funds? If it's a traditional loan, all of that's going to matter whether or not you do the LLC. And what are your goals on this property? Is it a short-term thing or a long-term thing? If it's a short-term thing where you just want to get in and get out, rehab and flip, or you see yourself taking over the property and it's going to be part of your personal inventory, then that might persuade you to do an LLC one way or the other. Where on the flip side, if it's going to be short term, not on your books for very long, then maybe you don't need to go through the whole process of doing an LLC. If it's something that you've acquired with the intention of holding for some time and you see yourself using that property, then yeah, you might want to consider doing an LLC. I like to recommend, again, this is all case-by-case basis, but usually what we might say is just form the LLC where the rental is located. Because at minimum, if you're dealing with a rental property, that state law is going to control if there's any inside creditors related to that type of business. Can you get the same amount of coverage through insurance? This kind of goes back to your financing goals. What's your timeline on the project? We do LLCs for all types of scenarios. You have single person investing, you have a couple going in together, or you have unrelated parties or friends or relatives that come in together, and we do multi-member LLCs. They're not as common as the first two, which are just individual investors or couple investors. Okay, to get your LLC, you just need to find out what state you're going to form it in and follow the state's rules and requirements. There's probably going to be an online process that you do that, get an operating agreement and file for federal and state tax numbers. I like to get federal tax numbers because if you're ever sued on that business, it's not immediately tied to your social security number and you have that separation on that end. And then look at what your designated registered agent services are going to require, and how much does it cost to pay your annual dues for your maintenance. So those are just the basic step-by-step requirements that you'd have to do in order to get to this stage, which is called a bank packet, where you would take all of those documents and paperwork and proof of registration, articles of organization, maybe a letter of good standing, and take all of that to a bank so that the bank can help you open your business bank account. I'm going to pause that here because I think we're at about 40 minutes. I know it's kind of going a little faster because I wanted to get to questions and answer period, but that's it for LLCs. LLCs, if I can break that down, I would say it is it's a very helpful tool in asset protection and investing. Whether you do it or not would depend on your personal situation. You'd have to look at a lot of those different factors that I pointed out, whether or not an LLC would make sense for you. And I would highly recommend speaking to a qualified professional that can walk you through all all of your different questions and concerns so that you know what you're getting yourself into, because it can be surprising down the road if you run into some obstacles that you weren't aware of, either in terms of lending opportunities or financing opportunities or even taxes. So, okay, Gilbert,
Thanks,
or
Jarrett.
Brandon. Okay.
Yeah. Yeah.
You guys
So we
there?
got a couple questions in the chat. So
Okay.
let's see how many we can get through before
Okay.
top of the hour. So
Alrighty.
one of the first questions I saw was from Chris Lumley. He says, I've seen discussion on both sides in favor of an LLC versus adding more insurance coverage on a subject property. With respect to the pro LLC side, is it more advantageous to create an LLC versus adding more and more insurance coverage?
Yeah, this is from Chris. Chris Lumley. Okay, yeah. Yeah, as I mentioned, Chris, it really, really depends on your situation and those factors. I like to look at, what's the financing structure of this project? How are you going to finance it? And then what's the long-term goal or short-term goal? What are the goals for this property? And that might help answer your question. If you have very little equity to protect, then umbrella insurance or insurance might be a very easy way to get yourself to a comfortable degree of, liability protection. So I guess it just might be up to you and your comfort level, but and also rounding out those factors that I mentioned.
Cool. All right. Next question from Ellard. Are you able to assist with LLC creation and structure in other states or just in Hawaii?
I mainly focus on Hawaii. If you need an LLC in another state, I can work with you personally. We can determine what state you're talking about and refer you to either a service that does all 50 states or someone that I might know personally. But I tend to shy away from doing work in other states just because it's impossible to keep up with all 50 states. So, but I'm available to talk if you need a referral.
Cool. All right. All right, cool. I believe you touched on the due on sale clause. Stacy Carroll had a question on that. Lacey asks, as a realtor getting into real estate investing, would you recommend opening separate LLCs for the designated businesses? So one for realtor, one for investments.
Okay, this is from Lacey. Yeah, Lacey, what you really need to do there is check with if you already have a license under a broker, I would check with the broker to see if your license can go under this LLC. I know that, and don't quote me on this because I'm not an expert in this, because I'm not a real estate agent. I know that there's some pretty strict rules regarding forming an LLC for your real estate agency business license and putting your license under that. So I would check with that. But if you're doing something on your personal side, like as a personal investment, forming your LLC either before or after, you have those options again. You can form your LLC before you even have a property in mind, and you go the full route of applying for loans through the LLC. In other words, a bank would underwrite the LLC and issue a loan under the LLC with you signing a personal guarantee, and you take the commercial rate that they might offer you, but then you know that it's fully protected and there's no due on sale or due on transfer worries there, because the loan is all packaged under the business from the start.
Alrighty. And then let's see if we can get this question in. So Katie asked, what insurance company should you use for an umbrella? Your primary home and auto insurance, or the insurance used for the rental properties, or a completely different company based on the premium / coverage?
Okay, let me try to pull that one up.
And I believe she has a follow-up question to that.
Yeah, yeah. Can you do umbrella within the LLC? Yeah, so these, Katie, what you really need to do is reach out to an insurance agent or an insurance broker, because most carriers, your auto, home, these major carriers are going to have some form of additional protections and things of that nature. But what I would recommend is when you speak to your insurance agent, it's great to know what the amount of coverage is going to be. But what's more important is to ask the right questions. And that would be, what does the policy not cover? Or what are the excluded activities? Or, what are the policy exclusions? And they might tell you, oh, okay, this umbrella policy doesn't cover an investment, rental property, mold, or water damage, or something of that nature. So it's important that you can kind of get familiar with what it doesn't cover. But these are questions, of how you structure your insurance company. I know there's and I don't know where you might be going with this, Katie, if you're thinking, okay, I don't want to mix too much between my personal and my business side. I want to keep things separate identities, separate bank accounts. I don't want to commingle anything. If you can get the company to write you different policies, that would be better. Of course, if you would have to get your LLC filed first and then apply for that insurance under the LLC. But those are questions that I think an insurance agent can answer.
Alrighty. And that's all the time we got for now for questions. Now, don't go anywhere yet, everybody. We're going to jump into breakout rooms in a short moment. But before we do that, Jarrett, just thank you very much for all the information that you shared with us tonight. I think a lot of people got a bunch of value out of it and might even be wanting to connect with you. So I know all your info was just on the screen, and I'm going to input it in the chat. But the best way for people to get in touch with you is through your email address. Is that right?
Yeah, you can email me or just call me directly. That's my direct phone number there. You can call that or send a text message. I'm kind of old school. I know Gilbert and Brandon were making fun of me because I don't have a website. I'm just kind of, I just like to just get to it. So yeah, if you email me, I'll respond. If you call or text, I'll call you back. But if it's something that I can't help you with, I'm happy to refer you to someone who might.
Awesome. Okay, cool. So yeah, guys, Jarrett's information is in the chat. So reach out to him if you have any other questions or if you wanted to connect with him. We are going to go into breakout rooms in a short moment. And Jarrett, I think if it's okay with you, he might be sticking around for that. So if you're in a group with him, that's awesome for you. You can you have him to yourself and you can ask him whatever questions you got. But before we get into that segment, I just wanted to remind everybody that we do have a meetup roster that, because we're not going to be able to get in touch with each person on this call, by filling out the roster, you're able to input your information and share that with everybody else on the call, and you can connect that way. We also have our Facebook group, Westside Meetup. We also have our Westside Meetup page, our YouTube channel. And then if you guys didn't get the link through the email, our email is in the chat right now. So if you just send us like a really short message, like, hey, my name is so-and-so, I'd like to be added to your email list to get updates for the next meetup. Send us an email to that email address, and then we'll just add you right onto our mailing list. Just know we're not going to spam you. We're not going to, solicit or anything. It's purely just for letting you know when our meetups are happening, giving you reminders and things like that. So if you're not on the email list, send us an email, get on the list, and then fill out the roster. Now, as we set up our breakout rooms, and it looks like we are good to go. Before we jump into that, I wanted to remind you guys of the fee for tonight, right? That's if you guys learned something, if you guys found value from our speaker, if it changed your perspective, right? I want to ask you guys, take a screenshot, let other people know about our meetup, invite people over, who you think would be able to get value from things that we talk about. Take a picture, share our meetup, invite people to it. And don't forget to tag Gilbert and I and anybody else that you connect with here on Westside Meetup. I'm going to put our handles in the chat. So make sure you do that. All righty. So it looks like we're all good for breakout rooms. Now,
Ready
as we
to
go
go.
into our, okay. What was that, Gilbert?
Yep.
We're all
I
good?
would like to just thank Jarrett for coming on. And yes, please stick around for our networking.
Awesome. Yeah. So we're going to do one round of breakout rooms. It's 25 minutes. and each group's gonna probably have 5, 6 people or so in the room. And to stay on topic of LLCs and asset protection and so forth, what I want to ask you guys to discuss is, does an LLC make sense for you right now in your investing journey? So I know we all are at different levels of experience and have investing for different amounts of time and so forth. But yeah, based off of what we talked about tonight and what Jarrett shared, does creating an LLC make sense for you right now? And then why or why not? So we're going to do that for the next 25 minutes. Then we're going to come back in here. We'll share some upcoming events that are happening and close out. So yeah, we will see you guys in about 25 minutes.
Here we go.
Thank you, Gilbert.
Thank you. I'm gonna jump into room 4. If you could jump into room 2.
Room 2. Okay.
Yeah.
Sounds
How
good.
you do that? How do I do that?
I think try pull up the